Good afternoon. Attorney Protective would like to welcome you to today's webinar, Conflict of Interest, Spotting Conflicts Before They Spot You. We will not be giving formal introductions today, so please reference your materials for information about today's speakers, Cal Watson and Kate Gould. And with that, I would like to introduce your first speaker, Kate.
Thanks so much, Erin. And thank you all for joining us today to discuss conflicts. This is a webinar we present every year because conflicts remain at the top of the list for malpractice claims. Conflicts of interest issues are common because of the frequency in which you must perform a conflicts check, that being for each new client and every matter, every time, and also because it can be difficult to determine whether a conflict exists. As we all know, it is challenging to decipher whether you have a conflict because the rules are complex and can be confusing. We frequently field calls on our risk management hotline from our insured lawyers seeking guidance as to whether a conflict has developed in their case. So we understand the challenges you face and appreciate the concern you have for avoiding conflicts. We hope today's webinar will provide you with some helpful tips for your next conflict of interest analysis. Let's take a quick look at the agenda. In today's webinar, we'll discuss the ABA model rules about conflicts and how to analyze conflicts in general. But you'll hear us say many times today, always check your jurisdiction's rules and their comments to ensure compliance in your state. Cal and I will then examine 12 different conflict scenarios with the hope of offering you some guidance with respect to these common conflict issues you may encounter in your practice. We will conclude with our webinar with our top 10 takeaways that we hope will be the practical tips that will stick with you as you evaluate conflicts in your practice, and then wrap up with our Q&A session as usual. So have those questions ready. With that, we'll jump into the stats. You may be familiar with Ames & Goff, a specialty insurance brokerage. They provide helpful insight and analysis into legal malpractice claim trends about every other year in their publication, The Lawyer's Professional Liability Survey. Their last survey was released in 2024, so we are eagerly anticipating their 2026 survey results. However, if I were betting, we will likely see conflicts again as the most frequently alleged legal malpractice error. Just like the prior survey in 2022, the 2024 survey showed that conflicts of interest far exceed any other error. Specifically, conflicts of interest remain the single largest cause of legal malpractice claims, with 9 of the insurers polled ranking it the first or second most common error. These statistics are particularly troubling for insurers and lawyers alike because conflict of interest claims can be very difficult and expensive to defend. In general, juries don't like when lawyers breach their duty of loyalty to their clients, which is really the underlying issue with a conflicts case. This can result in large verdicts. What's more, punitive damages can be awarded in a legal malpractice action due to conflicts in some jurisdictions, meaning an even more costly claim. This should drive home the point of how important it is to not gloss over the conflicts check before you or your office accepts representation. Regardless of how your firm handles the conflicts check, whether it's a report generated by your case management software and/or an email circulated around the firm with a potential client and matter, carefully and thoroughly review the new client matter and client relationship for any potential conflicts. I know it's easy to quickly skim that email and the flurry of emails you receive each day, but take time to review it. You may catch something or identify a relationship that the system did not flag as a potential conflict. As we're learning with all the cases in the news of lawyers getting into trouble for not checking those AI-generated case citations, having the human touch is critical, especially in the high-risk area of conflicts. Also keep in mind that conflicts checks are a critical component of the lateral hiring process. Ames & Goff highlighted that the inappropriate handling of lateral hires were an area of concern when it comes to conflicts. We'll take some time to address this later in the presentation, but you can also check out the Attorney Protective website for a few articles we have written on this topic. So now that we've scared you with these statistics, let's look at the rules. Cal?
Thank you, Kate, and welcome to all of our listeners, and thank you for those great comments about conflict analysis. Before we begin, I just wanted to let everybody know my perspective. I am a litigator who practices in South Carolina, but regardless of whether you are a litigator or a transaction lawyer, tax lawyer, family lawyer, plaintiff's lawyer, defense lawyer, you have to make sure that any matter or case you handle does not take on or come to you with an unresolved conflict, or that an unresolved conflict does not arise during your representation. And the first stop for any conflict analysis is your jurisdiction's rules of professional conduct. I think Kate mentioned that all of the states and the District of Columbia have adopted the ABA model rules of professional conduct. But as Kate said, it's very important to check your local rules, because in some instances, states either add or revise the model rules to reflect some local practice or custom that may be unique to that particular jurisdiction. The South Carolina rules of professional conduct do have a few different requirements than the model rules, so it's always important to read your jurisdiction's rules. Now, as we move through the webinar today, we will talk about and discuss and refer to several rules that are really important to any conflict analysis. And these rules, as you see, are on your screen. The rules, as they're listed, are basically divided into four different categories. We have rules that address your duties and obligations related to current clients, rules that address former clients, rules that address how and when conflicts are imputed from one attorney to another, and then finally, one rule that addresses your duties and responsibilities to a prospective client. We'll go through these rules in detail, and as we discuss some of the real-life scenarios, you will see how important it is to know where these rules are and what situations they address. And you'll also see why it's important to know with certainty whether a client is a current client, a former client, or a prospective client. And we'll give you some tips today in making sure that when a case or engagement is over, a current client becomes a former client. I'd also encourage you, when you look at your rules of professional conduct, to look at Rule 1.0. That's the rule that contains the definitions. And in the rules, as we talk about them today, you'll see that Kate and I will use the same terms over and over. These are terms like informed consent, or reasonable belief, or writing, or consult, or consultation, among many others. Believe it or not, these words and phrases are often defined in Rule 1.0. So as you look at the pertinent rules, don't forget these definitions, because the definitions can give you a great deal of guidance and also may impact the outcome of any conflict analysis you undertake. Also, be sure to remember the comments in the definitions, because there's lots of further explanation in those comments. Finally, any conflict analysis, regardless of what your practice area is essentially the same. First, you determine who are the affected clients and what is their status. Does a conflict actually exist? If a conflict exists, is it waivable? And if it's a waivable conflict, are the affected clients willing to give you written, informed consent to proceed with the representation despite the existence of the conflict? So that's the analysis that we'll go through today, and you'll see it over and over. So with all of this as our backdrop, I'll turn it back over to Kate for our first scenario.
Great. Thanks, Cal. And I think if you take nothing else from today, print off that slide. It's really a good checklist for the methodical approach you need to take when determining whether you have a conflict. So let's turn to slide 6. This is the first scenario we mentioned we would review: relationships with opposing counsel. Scenario number 1 may look familiar to you. If you live in a smaller legal community, chances are you may be practicing with law school classmates who have now become colleagues. The question is Is your relationship with opposing counsel a conflict? Under this set of facts, there's not a conflict under the rules. The fact that you both served as law review editors and are now on a local bar committee together doesn't create a conflict. However, you have to evaluate each situation and relationship on a case-by-case basis. If there is a risk your representation of your client will be materially limited by your friendship or relationship with opposing counsel, you do have a conflict under Rule 1.7A2. The ABA offers some guidance about friendships. In ABA Formal Opinion 494, it states that close friendships should be disclosed. So what does that mean? If you exchange gifts, spend time at each other's homes, or vacation together, you probably do have a conflict. However, like the relationship in scenario number 1, if you're just law school classmates or casual friends, you don't have to disclose the relationship to your client. Now, scenario number 2 on this slide is a completely different situation, and hopefully this is obvious. But if you become engaged, you would have to give the case up to someone else in your firm. The rule implicated here is also Rule 1.7A2, which prohibits lawyers from representing a client where the lawyer's representation will be materially limited by a personal interest of the lawyer. Here, that interest is clear. But keep in mind, this is a two-way street, so your significant other should likewise be performing the same conflict analysis at their firm. Note that because this conflict is unique to the lawyer and not the firm, the conflict could be cured by handing the case off to someone else. In general, when considering similar conflicts like this, you have to examine whether the nature of the relationship creates a conflict of interest requiring the lawyer to take steps to address it. Comment 11 to Rule 1.7 specifically identifies a personal interest as being when a lawyer is closely related by blood or marriage. Under such circumstances, the attorney cannot handle the case unless informed consent in writing is obtained from the client. Again, the analysis really turns on the nature and closeness of the relationship. The ADA distinguishes relationships as either intimate, a friendship, or an acquaintance, with intimate and close friendships, like we discussed, being the relationships you must disclose and obtain written consent for the representation or decline the matter altogether, which would be the case here. And as you'll likely hear us say many times today, if you're questioning or have an uneasy gut feeling about whether you have a conflict, you may wish just to hand the case off to someone else or decline the representation if your relationship with opposing counsel would create even the appearance of a conflict that you want to avoid. Cal, do you have any further thoughts on this one?
No, I agree 100%, particularly about the opposing counsel that you're dating or you become engaged to. Obviously, that is a very different scenario than opposing counsel that's a friend. In fact, in smaller jurisdictions, including the one I practice in, most of the opposing counsel are friends to some degree, and you have a personal relationship, whether through the bar organization or otherwise. So I really think you have to think long and hard about, does the relationship present that significant risk that somehow your representation will be materially limited by the personal relationship. And I think that is definite for scenario 2 and rare for scenario 1. Let's move to the next scenario. The next scenario is investing in clients. And the rule you at issue here is Rule 1.8. And so in this scenario, you've assisted your client in developing a business plan for a startup. And as a way of thanking you, the client offers you 10% of the shares of the company. Is this a conflict? What should you do? I think the main takeaway from this scenario is this is a very tricky situation. We probably need a few more facts because there's several ways that this scenario could go. If the shares are being offered to the lawyer as part of the legal fees the client owes the lawyer, then I'd take a look at Rule 1.5, and that should be the rule that you should consider. If the shares are given purely as a thank you gesture and not for payment of fees, then Rule 1.8c likely applies and could prohibit the transaction. Another complicating factor here is if the lawyer is planning to continue as counsel for the new entity while at the same time holding the shares, then 1.8a and the comments set out the process to follow that would allow a transaction like this to occur. But the bottom line is, I would be very hesitant to receive these shares without some other lawyer weighing in on the fairness of the transaction. There are a lot of pitfalls here, and in my opinion, it's probably not worth it. But Rule 1.8 is the go-to rule here, and can give the most guidance, particularly through the comments to Rule 1.8. Kate, what do you think? Do you think that there are some other issues here we need to discuss?
I absolutely agree with your analysis, Cal, and from a risk management perspective, these scenarios definitely give me pause and make me nervous. I think your comments about having independent counsel are certainly well taken. You should advise your client in writing about having another lawyer look at the transaction, but be sure you pick up the phone and call them too, and just explain the importance of this. I think that protects you and the client.
Absolutely. I think that's good advice.
All right, we're going to move on to the next scenario. Yeah, this is social media and technology conflicts. In this category of potential conflicts, we'll continue to challenge lawyers as technology and the way we interact with each other on social media evolves. As part of your firm's marketing plan, you might be asked by your firm to write blog posts, or you might have your own blog that's not associated with the firm. Either way, the nature of the information contained in your blog will determine whether you have a conflict in an ongoing or future case. So in this scenario, you wrote a blog post on your firm's website about what to do if you are sexually harassed in the workplace. A lawsuit is filed against the company that your firm represents, and the plaintiff employee that was fired tells their attorney they relied on the advice from your blog when they reported the harassment. Is your firm conflicted out of representing the company in this case? So here it would depend on whether the plaintiff's reliance on what you said in your blog would materially limit your ability to represent the company client. And unless it's a critical issue in the case, probably not. The company and your firm finance committee will be happy you can continue representing it. However, be mindful of the best practice tips listed on this slide. Whether in a blog or response to an online inquiry, avoid giving any specific advice or expressing your legal opinion. And in general, whether online or in person, avoid that "I know you're a lawyer and I've got a quick question for you" kind of scenario where you're cornered at a family function or barbecue. This should raise a red flag in your mind because of the potential for future conflicts, and not to mention the risk of inadvertently establishing an attorney-client relationship. In other words, you don't want to be conflicted out of representing a new corporate client because you casually offered some legal advice in person or online. And disclaimers, as noted here, are also critical when posting online content because they'll hopefully prevent you from creating, again, that unintended attorney-client relationship. As always, be sure to check your jurisdiction, especially with regard to disclaimers. For example, in Indiana, where I'm licensed, robust disclaimers are required and should explicitly state that the content is for informational purposes only, does not constitute legal advice, and that no attorney-client relationship is created by reading the blog or contacting the firm. Your state may also request that you note that the blog constitutes attorney advertising. So generally speaking, as long as your online conduct is consistent with the disclaimer, you could potentially avoid a claim. Cal, do you have anything to add to that?
No, I think the only thing I would reiterate is the disclaimer is so important here, and you covered that. But I would just remember that spending time on the disclaimer is time well worth it.
Okay, good. We're going to move on to our scenario number 4, litigation finance. And you typically see litigation funding companies financing tort and commercial litigation. And American litigation funders actually account for a 52% of the global multi-billion-dollar industry. So the question posed here is whether the fact that someone else or some other entity paying your client's bill is automatically a conflict. The answer is no, not automatically, but a few of our rules come into play here. First, Rule 1.782, as we've discussed, is at issue. The personal interest is the firm's financial position. The lawyer must ensure that payment of its fees by the litigation funder does not in any way materially impair their ability to advise the client to consider a course of action that may be best suited for them. In other words, you need to avoid the situation where your interest in resolving a case to collect a fee does not affect your duty of loyalty to the client. Next, the model rules concerning your independent judgment come into play. Rule 2.1 of the model rules commands a lawyer to exercise independent professional judgment in the representation of a client. Rule 5.4, the professional independence of a lawyer rule, broadly prohibits permitting a person who pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in performing those services. And finally, Rule 1.2 mandates that the lawyer shall abide by a client's decision whether to settle a matter. To meet these obligations, write a letter to both the client and the funder confirming, among other things, that it is the client and not the funder from whom the lawyer will take direction on key strategic decisions, including, and most importantly, the decision on whether to accept a settlement offer. Finally, remember our duty of confidentiality under Rule 1.6 will of course be an issue, as the funder who's footing the bill will likely think they should have access to all attorney-client communications. To comply with this rule, the lawyer should confirm each specific category of information the client has voluntarily authorized counsel to disclose to the funder, including ongoing reports to the funder of material developments in a matter in a letter. And as another reminder, as I ticked off a few different rules, read the rules, but also look at the comments. Particularly for our conflicts rules, the comments can be really helpful in helping you discern whether you have a conflict. Cal, would you agree with that one?
Oh, sure. Yeah, I think you did a great job covering that one. I agree with all of that. Let's move on to the next slide and the next scenario. The next scenario involves lateral hire, and it'll come on the screen in just a moment. But this is a common scenario when partners switch firms. For instance, if your firm decides to hire a lateral partner who's bringing a substantial book of business to the firm, what happens when the lateral partner brings a conflict And in this case, it's representing a co-defendant in a wrongful death case in which your client is adverse. What do you do? How do you avoid this situation in the future? I'd say this, in the real world, this conflict likely would have been identified before the lawyer arrived. And before you get to the conflict portion of this scenario, it goes without saying that you should always, always, always check conflicts before a lateral partner joins the firm. And when you do that, you can either work out the conflicts or determine that the potential conflicts could be a brick wall and you shouldn't move forward at all. So from a risk management standpoint, you should always make sure you inquire about any problem files. Are there red flags associated with any case or transaction the potential lateral partner brings to the table? Has a client questioned the way a case or transaction has been handled? Has a court issued sanctions or warnings to the lawyer? These are the type of questions that you need to have a frank and open discussion before a lateral attorney joins the firm. And if that happens, then these conflict issues can be sorted out before the transaction. But getting back to this scenario, if you discover that a lateral partner represents a co-defendant in a wrongful death case in which your client is adverse, you should look at Rule 1.7. That's the current client rule. Assuming the representation is directly adverse or there is a significant risk that your representation of the client could be materially limited by your responsibilities to the new client, then you would indeed have a concurrent conflict of interest, and that's explained in great detail under Rule 1.7. At this point, the lawyers reasonably believe that the firm can competently and diligently represent both clients. If that's the case, then the representation is not prohibited by law and the representation is not in the same proceeding. Then and only then could you then seek a waiver. The waiver has to be informed consent, and that's one of the defined words in Rule 1.0, and in writing, and that's also a defined word in the definition section of 1.0. If both clients don't agree, then you have another set of issues, but we'll get to that circumstance in the next scenario. But bottom line, check before the lateral partner comes to your firm. If he or she brings a conflict, then you go through Rule 1.7 analysis to determine if it is a conflict, then whether it can be waived. Kate, do you have anything to add to that one?
I would agree with your thoughts, Cal, and really that prevention is the key. Surprisingly, I think firms aren't doing the due diligence that they need to be doing. I mean, it's exciting to add someone with a potentially big book of business to your firm, but you've got to do your homework, and having the proper protocol in place should really avoid the possibility of any conflicts issues. And I'll again plug our website, as we've recently wrote about this specific topic, highlighting the importance of conflicts checks with lateral hires. So we're next going to move to scenario number 6, conflicts arising from serving as a board member. And I want to talk a little bit just in general about lawyers serving on boards and the possibility of facing significant conflicts. Before you accept a board position, it's crucial that you define your role. Are you serving as a board member only, or will you be a board member and the organization's attorney? It's crucial that you clarify your role before these lines get blurred to protect against potential conflicts or inadvertently creating an attorney-client relationship. If you're not the board's attorney, be mindful of the guidance you offer, and you're going to want to specifically state that you're not giving legal advice, so that's documented in the meetings. So what potential conflicts are you facing when serving as a board member? When you serve this dual role as a board member and counsel, conflicts can quickly arise. So, for example, an attorney should not participate in a vote to determine whether their law firm should be retained as outside counsel. Or if you offer legal advice, you can't vote as a board member on the same matter. So be on guard for potential conflicts so you don't risk an ethical violation. And I also want to mention the specific conflict of interest that can arise concerning your loss of independence when serving as a board member and the attorney. As a board member, you have a duty of loyalty to the organization, but when you're wearing your attorney hat, you have a duty to exercise independent judgment. So under Model Rule 1.7, this concurrent conflict of interest can develop if your independent professional judgment would be clouded when you're asked to give legal advice on a board decision. They have other opinions when wearing that board member hat. So just some things to keep in mind as you're considering board you might serve on. So let's get to this specific scenario. A senior partner at your firm is on the board of a local homeless shelter. Your local bar association refers a pro bono matter to you as part of its volunteer lawyer program to represent an individual who alleged they suffered a broken ankle when they tripped in the shelter. Does the partner's position on the board create a conflict of interest should you refuse to accept the case? And does it matter if you're handling the case pro bono? So this is a classic issue conflict. As a board member, the senior partner has a personal interest. Under Rule 1.782, a conflict could exist because of the significant risk that the representation would be materially limited by the lawyer's personal interest. So whether the lawyer's personal interest rises to the level to materially limit the representation is again going to be a case-by-case analysis. But overall, the optics here are not great. Probably best to decline this one. And you'll note this, what I'd consider a law school essay question red herring. The fact that you aren't being paid for the work and taking it on a pro bono basis would make no difference. Cal, would you agree with that?
Yes, in fact, that you took the words out of my mouth on the pro bono part. Whether you're paid or not, you still owe the same obligations, and I think that's an important consideration for everyone. All right, let's move to the scenario number 7, picking favorites, terminating representation to avoid a conflict. This is the classic question of whether a lawyer or law firm can dump one client in favor of a more profitable client. And you'll see the scenario where the associate agrees to handle a small collections matter for a friend, and then the hospital, against the hospital then approaches the senior partner to handle a larger matter, employment law matter. Does the associate have to terminate representation of the friend who's asked him or her to handle the collection matter so that the partner can accept the more lucrative work? Is this a conflict? Well, this is the classic question of whether a lawyer or law firm can actually dump one client in favor of another. And in this case, the one-time collection case is really the only thing standing in the way of the larger, more lucrative new matter. As an initial matter, this situation does in fact create a conflict under Rule 1.7. This firm would be representing two clients that are directly adverse to each other in a proceeding. So for purposes of Rule 1.7, it doesn't matter if the representation involves two different matters. But in this case, the conflict can be waived by following the procedure that we've referred to before, but it's outlined in Rule 1.7b. And assuming that all of the subparts of 1.7b are met, you can move to the next part of the analysis. But you should always look at these subparts carefully when considering whether a conflict can be waived. But in this case, the two representations are so different, I would submit that this is easily a waivable conflict. And as a waivable conflict, these lawyers could go through the process of a waiver by informed consent as long as it's in writing. So I think that's the answer to the scenario. So, but what happens if the associate's friend says, I don't want to waive the conflict? Well, one option then is to seek out a lawyer in a different firm and see if you can substitute counsel, with that client's consent. And a second option would be to consider terminating the representation altogether pursuant to Rule 1.16. And that rule allows a lawyer to withdraw as counsel if the withdrawal can be accomplished without material adverse effect on the interests of the client. Of course, this process is by motion and permission by the court. And if the court orders that you continue representation, then of course you must comply. But you can see this discussion in great detail in Rules 1.16C and 1.16D. So in short, this is a conflict that can be easily waived, but if it's not waived, the easiest path by far is a consent substitution of counsel. But all hope is not lost if neither of these options are available. So I think at the end of the day, this the second representation can be undertaken. Kate, what do you have some comments on that one?
I just say it's nice to have this slide in our scenarios because I think the waiver conversation is an important one. I think it's really easy to kind of get caught up in I have a conflict, we're out of options. It's part of the protocol to determine if you can take the representation even if you have a conflict. So consider your options, like Cal mentioned, if waiver is possible.
All right, let's move to the next slide and the next scenario. This is prospective representation of conflicts, and this is involves Rule 1.18. So if you have a prospective client issue, look at Rule 1.18. And in this case, you'll see on your screen that you discuss a potential client's case in a very general way, no agreements reached, and you are later contacted to represent the opposing party. And as you'll see if you review Rule 1.18, this is the classic case that it addresses. Bottom line is that you can have a general conversation about a case and then take the other side of the case. What you can't do, however, is to receive information from the prospective client that could be significantly harmful to that person in that matter. That's the reason that you should, as a matter of practice, try to receive only general information that you can use to determine whether you will take the case. And I know that's easier said than done, but that is the takeaway to keep in mind when you talk to a prospective client. The key question, obviously, is how much information did this first lawyer obtain in the consultation? I'd submit that if it's a general overview, as we said, then the second lawyer can take the case. If the first lawyer went into great detail with the prospective client, then there could be an issue. But even if you receive disqualifying information, another lawyer in your firm can take the case so long as you're walled off and you're not apportioned any part of the fee. And those details are also contained in Rule 1.18. And the questions on your screen present some interesting twists here. What happens if the first lawyer has not yet declined the representation in writing? I don't think that the existence of a letter declining the representation really makes a substantial difference to our analysis. I think the best practice by far is to have this letter in your file, but the analysis really turns on what type of information you actually received in the consultation. And this, of course, assumes that you did not take on the representation, and in that case, of course, all bets are off. My response to the other questions, though, is that you should assume that the information you received is an issue, and in that case, you could just be walled off and not apportioned any part of the fee. Um, but the firm could likely assume the representation, assuming you have these safeguards in place. So I think there are ways to deal with prospective clients, and Rule 1.18 is the go-to rule for that one. Kate, you have some thoughts on that one?
Yeah, that's helpful. And I know you said that the letter may not make a big difference here, but just a matter of general risk management, best practice. We always do recommend sending that declination letter. It might be a step you have overlooked in the past, but if you need a form, you can find these forms on our website. As far as receiving the disqualification of information, do you think, Cal, limiting that? I mean, is that something that comes with years in practice, or do you have any real world, advice you can give on how to do that?
How to limit the general conversation?
Yeah.
I think the key is to assess what type of claim the person has, and this would be more of an issue on the plaintiff side than the defense side, obviously. But I think the key is understanding exactly what the claim is, what the issues are, in a very general way, and who the adverse parties are. And sometimes the conflict or the potential conflict um, could be apparent just from knowing that information. So I think it's a case by case type analysis, and I think it's um, it's a situation you use your judgment as the conversation proceeds.
Yeah, that's helpful. I know it's a question we get a lot when we do this webinar, so I was just curious on your thoughts on the art of doing that. We're
Sure,
now
yeah,
going to move to,
that's a tough one.
yeah. We're now going to move to scenario number 9, conflicts arising from the use of an expert witness. And here, lawyer A represents client A and has hired expert A to assist it in a critical aspect of the case. Lawyer A also represents client B against adversary A in a vigorously disputed manner. The attorney representing adversary A names expert A, the same expert that lawyer A is using in the case with client A as the opposing expert. Is a conflict created? And if you followed all of that, I think maybe we need to update how we're identifying those players. But this is a tricky one. The issue involves using an expert in one case, opposing the same expert in a different case. And in many practice areas, there's such a small pool of experts that choices are very limited. So my thought on this scenario is that there could be a problem if you were limited by how you either present the expert or cross-examine the expert because of your duties and responsibilities to another client. So if that limitation meets the standard of Rule 1.7A2 that we've discussed today, there could be an issue. Suppose you might challenge the expert's credentials or manner of operation on cross-examination. If you forego those opportunities because it might impact how you will use the same expert in connection with a second client, this could trigger the rule and create a significant risk that representation of one or more clients will be materially limited by a lawyer's responsibilities to another client. To state the rule yet again, I think this scenario is very fact specific, so it's difficult to give a blanket answer. And presumably the expert would have also notified the other side of his or her association with the first lawyer. But it does illustrate that second part of 1.7A I just mentioned. Do you have anything to add, Cal?
Sure, I think this is another one of those that in the real world the expert would have, notified the other side of the association with the first lawyer. But it's definitely food for thought, and it definitely illustrates that second part of Rule 1.7a. Let's move on to the next scenario. This is scenario number 10. It involves former representation, and that'll come on your screen in just a minute. But the last scenario we'll talk about is, as I mentioned, former representation. The rule at play here is Rule 1.9. So in this scenario, a lawyer represents someone in a divorce action, and then 3 years later, the same lawyer is asked to be adverse to a company, and his former client serves on the board of the company. So is this a conflict? I would submit that the answer to that question is no, it's not a conflict. The second matter is not the same matter. It's not substantially related to the divorce action, and the former client is merely on the board of the adverse party and not the adverse party himself. I really don't see any problems with that representation. Now, it could get trickier if we change the facts a little. Let's assume the suit at issue involves a claim against the former client on a guarantee, and in that case, the lawyer should consider whether he or she obtained financial or other information in the divorce action that could be used against the former client in the guarantee suit. If the lawyer obtained information that's not public, Rule 1.9 does prohibit a lawyer from using information relating to the representation to the disadvantage of a former client, even if the matters are not related. So, again, there's no blanket answer other than it depends on the specific facts, the information obtained in the first representation, and the passage of time, because in this case, financial information could change drastically in 2 or 3 years. So food for thought. It's just a time that a former representation may create a conflict. Kate, you have thoughts on this one?
Yeah, I would just say as a practical matter, and you mentioned the passage of time can be a factor, but I think it does also drive home the need for that final closing or disengagement letter, and the importance of being able to, potentially categorize a client as a former client.
That's very, very important. Yeah, I agree with that.
All right, we're next going to move to scenario number 11, and that's placing the insurance carrier's interest ahead of the client's interest. So in this scenario, you're hired to defend a client involved in a car accident. The injured party's claim exceeds your client's policy limits, so the insured client wants to settle to avoid personal liability. However, the insurance company disputes liability and is willing to try the case. Do you have a conflict? So this scenario contemplates issues that can arise in that tripartite relationship between a lawyer, the client, and the insurance company. And it puts the lawyer in a tough position because the client wants to alleviate the risk of having a judgment against them personally. However, the company wants to try the case. So a conflict has developed here under this rule we've talked about today. What are the practical ramifications of this, Cal, though, in terms of withdrawing, or maybe when you withdraw under this
and I think
scenario?
It's key. Yeah, it's key to look at the policy. Each insurance policy has different terms, and some insurance policies anticipate situations like this. I've seen it on the other way, where the client wants to try the case and the insurance company wants to settle. But I think the first key is to look at the policy, see if it's been addressed in advance. If not, the key is open communication and making sure that the client understands, or the insured understands, exactly what the issues are, and the carrier understands what the issues are. And then if you need to take steps and it can't be resolved and you need to take steps beyond that, then I think taking them in full transparency and in writing is the best way to go here.
Okay, that's helpful. Yeah, helpful, good guidance. And as we all should do, look at your policy first, right? All right,
Sometimes
we're
the
gonna.
policy has defined what happens in advance, and if that's the case, then that is a different analysis than if it is, left unaddressed.
Sure.
But at the end of the day, the insured is the client.
Right, right. Do you want to take the changing terms of the contingency fee, the next slide?
Sure. Yeah, let's move into the next and final scenario. Um, this is a scenario where you've agreed to a contingency fee with a new client, but you discover during the case, the matter is more complex than you anticipated, and you want to increase the fee percentage. Can you do that? I'd say this is a tricky situation. The best practice, obviously, is that you include a provision in your engagement letter that addresses how and when a contingency arrangement may change and what the process is. And that way, it's determined in advance what you would do. Rule 1.5C is the rule that actually addresses contingency fees, and that's the general rule that allows for these contingency fees. Rule 1.5A is the other rule that becomes important here because that provides that a lawyer cannot make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. And then the rule provides a number of factors to consider. So I think that the first analysis here is, are you in fact complying with the rules when you want to have when you are requesting or having an increased contingency fee? And if you can satisfy that rule 1.5A and determine that your fee is in fact reasonable and complies, then I would treat it as a transaction similar to what we see in rule 1.8, and make sure that process is in place to have the client have independent advice that the fee is actually fair, is not overreaching, and that is communicated and agreed to in writing. So, I would definitely advise the client to seek outside legal advice to ensure that the new arrangement is fair. Um, Again, this is tricky, and it's much better to address this early in the representation through the engagement letter. Do you agree, Kate?
Yeah, I think that's really helpful guidance. And I think, too, obviously every situation is different, but, you may just accept your mistake too and move on with your, 33 1/3% too, and just, play the long game and do this work and hope the client brings their other legal work to you, or maybe some referrals as well.
So I think we move now to our top 10 takeaways. And I'll start. As I said at the beginning, look at the rules of professional conduct. They address nearly all the circumstances we've talked about today. And don't forget about the comments and the definitions. Kate, what do you have?
Absolutely. Yeah. Number 2, review the comments. You probably heard us say that as we looked at every scenario, but they can be incredibly helpful, especially your state rule comments in addressing potential conflicts.
Also, another very important takeaway is make sure your engagement letter clearly defines who the client is. Who are you representing and what are you doing? It's too easy for a client to misunderstand that if it's not clearly stated in the engagement letter. So that's a key part of any engagement letter.
I agree. And then when the work is done, make sure you send that end of engagement, that disengagement or closing letter, so you can avoid future conflicts potentially if you can identify that client now as a former client.
Right. Changing as you've seen from the discussion today, the rules and responsibilities related to current clients are very different from those that relate to former clients. So if you have the end of engagement letter, it immediately converts a current client to a former client, and the rules are different. If you decline to take the case, make sure that you inform that prospective client in writing. That came up in the scenario a few minutes ago. It is very important in that analysis what information you received, but the letter declining the representation changes a potential current client to a certain prospective client, and of course those rules and responsibilities are very different as well.
Cal gave a really nice explanation about seeking waivers and when you can do that. And our tip number 6 advises you just to go over and above what you might think you need to when you're explaining what the conflicts is, and make sure you put that in writing.
Also, I wanted to add one other comment on the end of engagement. A letter is probably the preferred method, but an email can do the same thing. The key is just making sure that there's no question that the representation is over and that you are no longer representing that client in the particular matter for which you were retained. Again, the letter is preferable, but you can certainly, as long as that's communicated in a way that advances that message, I think you're in good shape. I would say also remember that you're not alone in this conflict analysis. Be sure to take advantage of bar hotlines, the attorney protective hotline, friends, colleagues, the rules. There are plenty of resources available, and just remember that most of the situations you're facing when you look at a conflict have come up at some point in some case before, and there's probably some experience within a phone call or an email that can help you with the analysis.
Yes, absolutely. And as you've heard us say many times, check out Rule 1.0 and the definitions. You'll find a lot of those terms in the rules defined, which will assist with your analysis.
Also, a lot of, and you'll see it as you read the rules, but many times the analysis comes down to an attorney's reasonable belief. That is kind of a vague phrase, even though it's defined, but one way to check yourself is to talk to a colleague who may have no stake in the case at all and can give a more objective view of whether a conflict exists or any of these other issues that we've talked about.
Yeah, and just piggybacking off that, Cal, if you think you have a conflict, if you're unsure, you probably do. So as a last resort, rely on your good judgment and gut reaction to the situation. And with that, I'll turn it back to Erin.
Great. Thanks so much, Kate. So with that, like I said, a lot of great questions, a lot of great compliments coming into both our speakers today. But our first question is going to be, what is your opinion on potential conflicts when forming an LLC with multiple members?
I can take that. There can be many conflicts depending on the facts, the specific facts, and the specific interest. But I think you have to treat each member and go through the analysis to see if there's in fact a conflict. The same things we talked about today. I will refer the person who asked this question to Rule 1.13, and that's the rule that deals with organizations as clients. And also Rule 1.7, where you go to do your analysis, look specifically at, I think it's comments 32 and 33 that address this particular issue. But that would be a situation where you could be faced with conflicts or not. So it depends on the interests of the particular members. Kate, do you have thoughts on that one?
Nothing further, Cal. Yeah, I think that's good advice and reference to those rules.
Great. Okay, so another question that came in. When walling off a conflicted attorney, what steps are sufficient?
I can take a stab at that one. I believe screened or walled, it's probably screened, is a defined word in the definitions. When I was preparing for this, I think I saw that there. And so it can give guidance. And I believe I saw a comment in under Rule 1.0 about screened clients and what it takes. That is not an issue that comes up very often, but I believe it's in the definition rule. I would say this, there are so many ways today with technology that clients can be screened or walled off. You can lock the files lock electronically so that electronic files are only accessible by the people working on the file. You can, I think if I remember correctly, the comment requires or suggests that lawyers sign an undertaking saying that they will not speak about the particular issue that's being screened off. So there are ways to do it, and it's probably more of an IT question than a ethics question. But this is a common issue that a lot of law firms face because of the things we've talked about today. Kate, do you have some thoughts on that one?
No, I would agree, and I think if you are the conflicted attorney too, I mean, it is your obligation to remove yourself from any conversation. If this case comes up, aside from all the firewalls that can be put up on your computer, just avoid any situations, just to make sure you maintain that wall status, we'll call it.
Yeah, and it looks like I'm looking at it now, it looks like it's a reasonableness standard. So, that's what a similar firm would do under similar circumstances.
Great. So we'll ask one more question. And again, we're past the 60-minute mark, so it's not necessary to just stay on the line for this last question in order to receive credit today. But this is one that actually quite a few attendees had asked. Generally, does a lawyer's representation of a company automatically impute a conflict as to each individual employee from that point forward?
I can take that one, Cal. The short answer is not necessarily, and as with any good answer to a legal question, I'd say it depends. It's going to be a case-by-case analysis. What capacity you're representing the company. Obviously, if you do their employment work and you're approached by a employee with a wrongful termination claim, yeah, that's going to be an issue. But if they have a family law matter they want you to handle, you may in fact be able to do that. Do you have any thoughts on that one, Cal?
No, I think you hit the nail on the head.
Yeah.
Great. Well, at this point, we are out of time for further questions, and that will conclude today's event. And on behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. And I would also like to thank our speakers, Cal and Kate. So thank you so much, and have a great day, everyone.